and then I pass it to our experts. I want to, as always, recognize Wendy Brennan from my staff, who organizes these events and is a walking encyclopedia on these kinds of issues. So Wendy, wave in case somebody doesn't know you. And that's Brad Usher, my chief of staff, who also decided to hang out in the snow with me. This three-part series, and this is part 2, is on later life planning. And the topics tonight are around important documents. And actually, they're really crucial to have the documents you need ready and available so that you don't have to deal with them when things go wrong. You want them first. So we're very glad to see so many of you here in the snowstorm. We, of course, always want to thank Weill Cornell and New York Presbyterian for partnering with us, and for Weill Cornell having this great conference space that we can use for important events like this. So again, as I said, tonight's program is covering important documents: wills, living wills, healthcare proxies, and power of attorney. First, you will hear from Lisa Rachmuth, who's the Deputy Director of New York City's Elder Abuse Center Multidisciplinary Team. And Lisa will share her personal story about the importance of planning. And next you will hear from Michael Bond, an attorney who specializes in estate planning and addressing the planning needs of older adults. Then Lisa will give you a quick overview of the center and other resources you might find helpful from them. And we will have a Q&A at the end, and it's such a nice, small, intimate group. We're not going to worry about cards. You'll just raise your hand when we get to the Q&A, and we'll try to answer as many questions as we can. And I also just wanted to, before we start, remind everyone that our closing third session is when? Now I don't remember. Thursday the 29th? Thank you, Wendy. Thursday the 29th. And so I hope we'll see everybody back here again. And we'll all have Thanksgiving in between now and then. So I hope you all have a joyous Thanksgiving, whatever you end up doing. And if you live in the community and you don't have plans, there are a number of organizations who actually have Thanksgiving dinners right here at the Lenox Hill Neighborhood House. I know it's the one closest to here, 70th Street. And so nobody should feel like they don't have plans for the holidays if they want them. I thank you again for coming. I hope everybody gets home safe this evening. It's going to turn to rain eventually. And I want to pass it over to Lisa. Thank you both so much.
Thank you so much. Thank you. Good evening, everyone, and thank you so much for coming out on this really gorgeous evening. I think I just advanced your, sorry, you're okay with that? Okay, sorry about that. So as Liz Krueger said, my name is Lisa Rachmuth, and I'm the Deputy Director of the Enhanced Multidisciplinary Team Expansion here at Weill Cornell Medicine through the New York City Elder Abuse Center. The New York City Elder Abuse Center sits within the Division of Geriatrics and Palliative Medicine here at the hospital, and we are just so happy to be part of this event and to be able to talk to you in conjunction with Mike about important documents and about the work we do. But just to kind of frame what we're going to talk about tonight, I have a personal story. I had shared it with Wendy when we were talking about planning for this evening, and we thought it would be a really great way to get you into the frame of thinking about why it's so important to talk about these later in life planning issues. A couple of years ago, we had a very, very serious and very traumatic family event occur within my own family. And the event it involved my immediate family, the entire immediate family. And we really were very, very busy in trying to work through some of the physical and some of the emotional issues around this traumatic event. We didn't think about a whole bunch of other things that were peripheral to the event. So we made it through the event, and I'm happy to say that we're all healthy and we're all okay. But we also didn't think about the long-term effects of what had happened to our family and what our family had gone through and what we had experienced in relation to our future and the future of our children. Earlier this year, my husband and I were planning for a big trip, and we were busy getting our trip together and trying to plan and make all these arrangements, and we were getting travel insurance. And as part of the travel insurance, we were filling out lots of documents, and my husband and I were doing the documents one evening together, and we both looked at each other almost at the same time and said, "Oh my goodness, our wills." Our wills had information and had named some people in the wills that were part of that traumatic event, and if they were to still be named in those wills, in our wills, and something were to happen to us, our children would be put in very, very dangerous situations, very, very serious situations, and it really would have been detrimental to them. So very quickly we scurried. We found our wills. They were locked up. We found them, and we tried to contact the attorney who had originally drawn up our wills. Couldn't find him anywhere. Went through Google, did everything we could, couldn't find him. So we decided that we needed to probably draw up a new will. We didn't have very much time. We were really nervous about planning for this trip and getting everything together before then, and we knew it would take some time. We were put in touch with an estate planner and an attorney who said, "We can fix this quick. We can do something really quickly." So he put a codicil in place that really amended some of the things in our will, and it was temporary. But he was really able to do that very quickly. And while we were putting together the information for the codicil, we were talking about estate planning. We were talking about what really goes into it. And we partnered with this particular attorney, and I'm sure Mike can talk about this in a little more detail, but we partnered with this particular attorney because he really spoke to us about revisiting our will, revisiting our estate planning along the way, not just being stagnant in our planning. So really looking at things as they change in your life. And your life will change and your situations will change. And it's just so important to revisit things as you go along throughout life. I'm going to come back and talk to you a little bit later about our program, what we do, but really just thinking about how you put things in place so you're always on top of it. And that's not to say that you always want to be focusing on death and dying, but you do want to be really aware of how you can plan for yourself in a meaningful way for yourself and your family and the people that you care about. Okay? You're at a hospital.
That's right. Well, thank you. Fortuitous. Hey everyone. That sounds. I'll try to talk loud instead of, and then if you can't hear me, let me know and I'll talk into the microphone. Can you guys hear me, or should I talk to the microphone? Yeah. Okay. It just sounds so weird up here. So first, I just wanted to thank Senator Krueger and Wendy for putting this, and everyone else for putting this together and having me here tonight, and Lisa as well for helping us all plan this. So I'm Mike Bond, and I am primarily an estate planning attorney. I have an office downtown on John Street, which is near Fulton Street. And so I just wanted to talk a little bit tonight about some of the basics of how to define what your estate is, and to talk about the key documents, which are a will, a healthcare proxy / living will, and a durable power of attorney document. And I'm also going to touch on a fourth document that hopefully will be of interest. Sorry, I don't usually look this wet either. It's just a really hard time getting here. Yeah, I know, and I appreciate everyone coming out. I thought it might be an empty room. So I think that Lisa actually touched upon the answer to this question with her story. I think that unfortunately, a lot of times there is a triggering event in somebody's life that makes them say, "Oh my gosh, I need to do a will. I need to get these things in place. And it is often a crisis situation. Either you have documents that no longer really reflect your wishes and your needs, or you don't have them at all. I get a lot of calls and emails. I'm going on a trip next week. I need to do a will. And it's like, okay, well, you had it's your first trip ever, but that's not the ideal way to do it, because you really it should be a deliberative process. And I like to have a really kind of robust conversation with clients before we set things to paper. And I've had quite a few people come in over the years who have done wills and documents previously with other lawyers, and they come into me to update the lawyers. It's sort of like if Lisa had come to me in that same scenario. And we go through, they ask questions, we go through sort of a lot of what I'm going to talk about tonight. And oftentimes they'll say, wow, my other attorney never told me any of this. And they kind of had no idea really what they signed. And that can be dangerous, because like your will reflected your wishes at the time, but if you had not really thought about, if it hadn't crossed your mind, or if you hadn't gone to a lawyer who actually sounds like he shared a similar philosophy to my own and thought, let's not just change some names and swap some stuff in and out, but let's rethink this. Like, how has your life changed? And people often ask me, well, do I have to come back to you every 5 years or any certain interval? And the fact is, I mean, when you sign these documents, they're as good the day you sign them as the day you need them. But I always tell people, when there's a life event, something, a marriage, a divorce, children being born, children dying, significant changes in wealth, things like that, it's a good time to just either to revisit the documents you have. And it might be that you don't need to make any changes after all, but that, I think, as a rule of thumb, that's a good time to rethink these issues. And so let's see, sorry. And so to also answer that question, these documents, a lot of times people think that people have a natural and I think very understandable resistance to entering this process, because they think they're planning their death. And that's an unpleasant thing for people to think about, which I totally get. But some of these documents really are about protecting you while you're living, which would be a healthcare proxy and a living will, which is a document which we'll talk about very shortly. And then a power of attorney document, which we'll also talk about. And then it also, the documents that have to do more with when you're gone are a will. And then a document, I would say it has a gruesome name, but basically it's the designation of agent for disposition of remains. And that's a document where you can name somebody who would be able to carry out any kind of funeral, burial, cremation type wishes that you have. You can express those wishes in the document. If you have a family plot or an advanced funeral plan, that can all be reflected in the document. And we'll talk about that in a little more depth as we move forward. So I'm going to focus on the documents that are useful during your lifetime first. So the first one is a healthcare proxy and a living will. And some lawyers are going to give you two documents, and some will combine it into one. I happen to combine it into one. I'm not sure if the handouts include something from New York State. There's a sample healthcare proxy document, and there might be, is the brochure there too, the longer one? Okay. And then there's one also issued by the State Attorney General that's a little bit longer, and it gives you some information both about healthcare proxy documents as well as the the living will and advanced planning document. I had to look at those things before I came over. I don't use those documents myself. There's nothing wrong with the state's document for healthcare proxy. The document I provide, and I'm not saying longer is better, but the document I provide is like a 9-page document, and it goes into a lot more detail about what powers you're authorizing your healthcare agent to have, and identifying certain key terms and definitions and legal terms that a hospital legal department, for example, is accustomed to seeing. And so if there's any question about the document or what your wishes might have been, it's a much more thorough explanation of what your wishes are. And I think that's helpful in the context of if a hospital is reluctant to honor wishes, the more comprehensive the document, the more clear it usually is. And I think the greater chances that it will actually be honored. And And if you were to use the document that was provided, my one word of warning or advice would be, it has to be witnessed by two people, and the witnesses can't be your doctor, and it can't be the person you name as agent. So if you're going to try to do it yourself, making sure it's done signed and executed properly with all the required formalities is very important. So the first portion of the document, or in some cases a separate document, is the healthcare proxy. So a proxy is basically a person that you appoint as your agent to be able to make medical decisions for you and to also carry out whatever wishes you hopefully may be expressed in a living will. And so I often recommend that people name one agent as a primary agent, and it's always good to name an alternate or two. And the document authorizes that agent to make any medical decisions that need to be made. The document also, in my document anyway, it lists in many cases I'll include provisions about visitation rights, and I include those often in situations when there's not maybe a legal spouse involved, or there's a friend or a partner or something like that, and you just want to because those visitation rights are guaranteed by law, but I think it's always good to sort of state them in a document so it's very clear who you want to be able to have visitation rights. And it also gives the agent power to have full access to your medical records and to confer with your doctors so that any decisions that they make are informed decisions. And it also allows your agent to hire and fire doctors or other medical providers, or to transfer you between facilities or move you into hospice care or anything else. So that's the first component of this overall healthcare document or documents. And then the second portion, or the second document, is the living will, and it's a term most of you have probably heard. And that's where you express your own wishes. Now, New York State doesn't have a form for that, and in reading through the brochure, it was helpful, but it didn't really give you any guidance as to how to draft one. And the problem I've seen a lot of, you can Google and you can find sample living wills and things like that. And a lot of times it's I want this, yes or no, or do this, yes or no. And it's like check boxes, and I don't know. Personally don't think that's the most effective way to do it. So what I do, and I think many other attorneys do, is I have a document drafted that, again, like I said before, it identifies like what does treatment mean, what does serious illness mean, and what does pain relief mean. I mean, it goes through some of the key issues that can come up, and then it provides what your wishes are in that area. And so I don't say to clients, oh, what are all your wishes? I sort of provide a draft document that what I find is what most people want, which is if doctors agree that I'm not really going to have a meaningful recovery, I'm not going to be the person that I was, make me comfortable, treat me for pain, but don't keep me hooked up to machines. So that's the default language I use, but I'm exaggerating, but I've had clients who say, if I sneeze, pull the plug, and then other ones who are like, if one cell is left in my body, keep me alive. So we can so I'm exaggerating, but the language can be adjusted. And I find that that's a very helpful document to have for your agent, because you could do just a healthcare proxy, but without that living will component, that agent, if you haven't had a conversation with the agent about all your wishes, they're kind of in the dark as to what you really want. So they can make all the decisions they want to make, but they're going to have probably doubts about, are they doing what you would have wanted to do? So I think of the living will as like a roadmap for the agent and for doctors. And let's see, was there anything else? And if you did choose to prepare something like that yourself, I would just try to be as thorough and clear but thorough as you can be about what your wishes are. And I always suggest that people provide copies of the healthcare proxy documents to all the agents that they've named in the document. If you have a primary care physician or a doctor you see regularly, you might want to give a copy to that person to put in your file. And there are also services that allow a person to upload a healthcare proxy document, and then they'll send a wallet card, and it has like a PIN number. So if something happened to you, chances are you don't have your healthcare proxy in your back pocket, but you might have that card in your wallet. And there's like a PIN number on it, and once the company verifies that the hospital is legit and all that, the hospital can download the healthcare proxy and have it. So that could be a good service. And at a minimum, you might want to at least do your own little card that you'd put in a wallet that would maybe at least just list who your primary agent is and how to, my healthcare agent is name, address, phone number, email address. And so the next document that's useful during your lifetime is a durable power of attorney. And that's a document, it's similar to a healthcare proxy, but in the context of everything but healthcare. And so you name an agent, a person who you authorize to conduct any sort of personal or business transactions that you need done. And that could be something like paying your rent. Some people have dementia and they need their bills paid or something. It could be preparing or filing tax papers on your behalf, applying for government benefits on your behalf. So there's a whole host of powers that are put into this power of attorney document. And just to go a tiny bit into the nuts and bolts, and there's the skeleton of the document was drafted by the New York legislature in 2010, and I think that's included in the handouts. And if you do review it, you'll see there's a whole laundry list of powers. It's not there? Well, if it's not in there, if you Googled New York power of attorney form, it should come up right away. And again, the key there, if you chose to do something yourself, is to do it properly. So the skeleton was written by the legislature, and then attorneys or other people can add modifications. And the principal, which would be you, sign the document granting the power to the agent. The agent signs the document accepting the power. And once both signatures are on the document, that person has power to act on your behalf. And if you're uncomfortable with someone having that kind of power while you have your own ability to take care of affairs, there are ways that language can be adjusted so that the document would only be effective if you're incapacitated. Isn't always the best option, but for reasons I won't go into right now, but it is an option. So now we'll move over to two documents that are important to do while you're living, but really apply after you're gone. And this is really, I don't like to think of it as planning your death. I think of it more as providing for and protecting the people you care about and who you want your assets to pass down to in a efficient way and an easy way, and also to just to try to get your sorry, like it's still a little flustered. So I think the best way, I think a good way to frame your overall estate, like what do you have, into two buckets. And so there's a probate bucket and a non-probate bucket. And so a probate bucket, in short, are any of your assets that pass through your will. And then the non-probate bucket are assets that pass outside of a will. So I think it might be easier to talk about non-probate first. So non-probate assets would be things like that you own jointly with somebody else, where the surviving joint owner becomes automatically full owner upon the death of the other owner. Life insurance policies, where you name a designated beneficiary, that passes outside of the will. It passes according to the names you gave to the insurance company. And most retirement accounts have similar beneficiary designation options. And then the probate estate is what passes through the will. So that would be any real estate or other property that you own individually, your stuff, like your tangible items. In most bank accounts and taxable investment accounts don't have the option to name a beneficiary, but that is changing a little. So I always suggest, since when clients come to me, they're already in that frame of mind of like getting this stuff settled. So I always say it's good to call all the companies where you have accounts and policies, see who you've named, make sure you've named someone at all, and make sure it reflects your wishes. And the more money or more assets you can pass outside of a will, I feel the better, because if you have a life insurance policy or a 401k or something where you've named beneficiaries, if you died, the beneficiary basically goes to the company with a death certificate and they fill out a claim form and they get a check like in a week or something. Whereas with a will, first you have to go through the process of getting the executor established legally to be able to go to the bank and close out an account, and that definitely takes minimum a couple weeks, and oftentimes a lot longer. And then the executor has to marshal all the assets, they have to pay all the debts, and I won't go into the technicalities, but a prudent executor is not going to give any money out to any of the beneficiaries until at least 7 months after they've been authorized to act as executor, because creditors can file claims against the estate basically for 7 months, and if the executor gives out all the money on month 5, and on month 6 the IRS or Visa comes knocking and they want money, the executor has to either try to get money back from the beneficiaries, which good luck, or they're personally liable out of their own pocket for the debt. But after 7 months, they're no longer personally liable. So very rarely are you going to see probate assets distributed before at minimum 8 months after a person dies. But those non-probate assets go much quicker, and for some people, getting those assets transferred really can be important for the, say, a surviving spouse to be able to continue paying the mortgage and having the same sort of quality of life that they had when the other spouse was alive. And other times it's less important. Like I had a client pass away last year and all her beneficiaries were just friends. So it was all like a gift, and it took a year to settle, but no one was relying on that money, so it wasn't such a big deal. But there certainly are scenarios where people really are relying on being able to use those assets. So if you don't have a will and you die, basically the state writes your will for you. And so there's a whole series of laws, generally called intestacy laws, and it governs very rigidly who can serve as executor if you die without a will, and where your assets go if you die without a will. And it's one size fits all, and in some cases it might match what you would have done in a will. In other cases it might be dramatically different. So here's a few of my family members. And so those are my parents on top and my brother and his family on the bottom. And so I'm going to talk quickly about what would happen without a will if you're a married couple and you don't have a will. So if you're a married couple with no children, of course my parents have children, but when I say children, I mean even adult children. If you're a married couple without children, the surviving spouse gets everything. If you're a surviving spouse with children, even adult children, the surviving spouse gets $50,000 and then half of the balance, and then the children share the other 50%. And that could work out, but it could also not work out. Sometimes the surviving spouse, they really need and rely on all the assets available that was once available to the couple. And especially if you have young children, all that money has to be held in a trust that's court supervised until the child turns 18. So that's more, and if you need money from that trust to, say, provide for your child, you have to go to court and explain why you want the money, and then the court has to approve it. So it limits the flexibility of a parent with minor children, and it also could just be very detrimental to the continuation of the surviving spouse's lifestyle. And then if you're an unmarried couple, and it doesn't matter, so these are my aunt and her boyfriend of many years on top, and then some close family friends who were in an unmarried same-sex relationship, and the law doesn't treat either of them any differently. They would get absolutely nothing. The surviving partner would get nothing under the law if there wasn't a will. Doesn't matter if you were together 50 years and you lived like, as man and wife, it doesn't matter. So the only way you can provide for an unmarried partner is either have a will, and if you name that person as a beneficiary of life insurance or other policies and accounts where you can do so, that works, that's fine. But if you're not legally married and you don't have kids, then all those assets passing down that would have passed through a will are going to go to, first it's your parents if they're alive, then grandparents and siblings and nieces and nephews. And that certainly is probably not who you want to provide for first if you are in any kind of an unmarried relationship. And then just quickly, 4 things that a will can do that cannot happen if you rely on these intestacy laws. So when you have a will, you get to decide who's going to settle your estate. And it's not, most spouses and partners, they usually choose each other, but not always. Especially people come in and they're in their 80s, they might think that maybe one of their adult children might be a better person to handle the responsibilities of being an executor. But again, it's a very rigid list under the intestacy laws of who gets to serve as the executor. And then, as we talked about, it lets you decide who's going to get the assets that pass through your will. So it can be unmarried partners, could be family members further down that list. So you might want to provide for nieces and nephews, but you don't want your brother, who is the parent of the nieces and nephews, to get the money. You want the younger generation to get it. And so a will can accomplish that. Friends, lots of people leave assets to friends and also to charities. And friends and charities they don't exist in the intestacy laws. If you happen to have minor children in a will, you can also designate who you want to be the guardians of those children. Absent that, then there has to be a court proceeding where a judge is going to decide who will be the guardian. And that can cause a great deal of expense and delay at a time when your child is probably already going through the worst experience of their life, and then that just prolongs the uncertainty. And it could potentially lead to a family fight or something like that. And then the reason I have our family friend on here again is because back when the estate tax levels were lower, he inherited $8 million from a friend. And the friend left everything to this guy Buzz, but didn't want to do any tax planning at all. He just wanted to do the will. And so Buzz, because there was no tax planning in the will, ended up with $4 million, which is still great. But he could have had a lot closer to 8 if the person who died had done some planning. And the reason I put a good problem to have is because most estates these days aren't taxable. Because right now the federal exemption level is 11 million and change. So anyone's estates who are worth less than 11 million don't have any estate taxes. If you're a married couple, you can combine that and basically make it 22, closer to 23 when you add in the change. And in New York State, it's roughly 5.5 million per person. So probably closer to 5.8 million. So estate taxes, it used to be, there's been so many news stories and articles and everything about estate taxes. And if you happen to be lucky enough to fall into one of those categories of net worth, then you could put provisions in a will that could potentially lower or eliminate the estate taxes. And the final document is that gruesome appointment of agent for disposition of remains. And this document and the law behind it came into existence during the AIDS crisis, when a lot of people would pass away from AIDS, and then a estranged family would swoop in from some other place in the country and take the person off, and there might be a surviving partner who is totally left in the cold. So this law came into existence so that you can name anyone you want to have the authority to carry out and make any type of funeral, burial type decisions that you have. And again, there's probably not a need for me to provide this for married couples, but I do anyway. But it's especially important if you want a friend or a partner or someone like that to have that power. And also, even with a family, sometimes families disagree. And so bronze casket or ivory casket or whatever, if there is a conflict, the person who's named in this document has the final say. And you can also express any wishes you have. Some people choose not to think about that. I've had another exaggeration, but this is actually a true story. I've had one client who said, "I'll be dead, put me in a hefty bag, I don't care." And I have other clients who already have mixed CDs made for their memorial service and the funeral. So it can run the gamut, and to the extent you have any wishes in that regard, you can express them in the document. And if you have a family plot, or if you have a advanced funeral plan, information about that can be provided in the document. And again, like the healthcare proxy, where it's helpful for a person to see it in writing and even maybe hear it from your own mouth about what your wishes are. Same thing with this document. If you express wishes, obviously planning a funeral is not pleasant under any circumstances, and it's usually very rushed and very stressful. So to the extent you provide a roadmap for the person that you've named, it gives them confidence that they're doing what you wanted, and it can also short circuit some of those arguments that might crop up between family members, because they say, "Oh, well, clearly, he or she wanted this." So that's basically what I was going to talk about. And again, during the question and answers, I'm happy to answer any general type questions. I can't really address personal situations in this venue, but but we can certainly, I'm sure, possibly this conversation has raised some questions in your minds. So thank you. And I guess we're going back to Lisa now.
So I'm going to shift gears a little bit and talk to you a little bit about the New York City Elder Abuse Center and the work that we do here at Weill Cornell. There were some brochures outside. I don't know if everyone got one. There were two brochures. One was on the New York City Elder Abuse Center, and the other one was on the New York City Elder Abuse Center's helpline. So I wanted to talk to you about those two programs that are part of the Division of Palliative Care and, the Division of Geriatrics and Palliative Medicine. You got both brochures, Wendy? Thank you so much. So let me just, I'm going to read you the mission of the New York City Elder Abuse Center. New York City Elder Abuse Center aims to prevent abuse and assist people 60 years and older who are abused or at risk of abuse, as well as their family members, friends, and neighbors. So we do this by helping to improve how professionals, organizations, and systems respond to their needs, and by developing services to meet those unmet needs. Our core services are develop innovative solutions to elder abuse, neglect, and exploitation, coordinate and facilitate multidisciplinary teams, and I oversee the multidisciplinary teams, provide case consultations to professionals assisting victims of elder abuse, assess hard-to-find specialists for multidisciplinary teams and case consultation, raise awareness, that's one of the things we're doing here tonight, through consultations, workshops, and in-service trainings. And I want to introduce you to Ayanna Mortley. Ayanna Mortley is our workshop training coordinator, and she is available to work with different communities, talk to different professionals who would like to, and community members who would like to have workshops on elder abuse in their areas. Sorry about that. And engage professionals and others through the elder justice blogs, social media, through presentations at conferences across the city, state, and country, and actually internationally. Our co-chairs present at conferences across the world. And we envision a caring community in which all older adults live with dignity and well-being, free from abuse, neglect, and financial exploitation. And to that end, we have established the enhanced multidisciplinary teams. And the enhanced multidisciplinary teams are teams of professionals. So we have geriatricians, geropsychiatrists, and those are psychiatrists who serve people over the age of 60. We have forensic accountants. Everyone familiar with the term of forensic accountant? So we have, okay, forensic, thank you. Thank you for saying no. Forensic accountants are individuals who have an accounting background, but their particular work involves looking at financial statements, the financial history of someone, to really uncover where their money is going, what they're doing with their money, what's happening with their money, and their financial resources that are available to them. We have the wonderful, unique opportunity to work with a financial accounting group, and they're out of Rochester, New York, who specialize in financial exploitation. So they have a special expertise in really looking at financial records and uncovering financial exploitation. So much so that they testify across the country on cases of financial exploitation, given the documentation that they work on. They have the ability also, in some cases, to uncover who is actually committing the financial exploitation in different cases. So we work very closely, our teams, I'm going to tell you a little bit more about our teams. Our multidisciplinary teams work with financial institutions. We have the opportunity to work with the national group that works with financial institutions, and we also have very good relationships with a lot of local and larger banks across the country to help uncover financial exploitation. So in addition, geropsychiatrists, forensic accountants, we have civil legal attorneys that sit on our teams and help us and advise us on best courses to take on the elder abuse that we're hearing about. And our cases are really cases of complex elder abuse situations, and they require, most of the time, multiple specialists to really weigh in and come together and talk about how we can put together an action plan to hopefully diminish risk for this vulnerable elder. We don't actually see the elder in this environment. We're hearing about the case, and our professionals are weighing in based on their areas of expertise. So no one of us, and you can probably attest to this in your own lives, no one of us is an expert on anything, on everything. We're an expert on one thing, maybe two things, maybe three things, but not on everything. So we bring this group together, and it's a brain trust. It is sitting in a room with professionals who really, when you put everything together, really have a wealth of knowledge to hear these cases. Now, does everyone who has, elder abuse in their life come before our teams? Absolutely not. Most elder abuse in this country is uncovered. So we don't hear about most elder abuse cases in this country. It's it's a family secret. They're things that are kept hidden. We work very closely with organizations to help make it much more of a situation where we can talk about it, and we can also help some of the most vulnerable people in our society really get help as quickly as possible. Another service of the New York City Elder Abuse Center, and you have the other brochure, is the helpline. So the MDTs, the Enhanced Multidisciplinary Teams, are for professionals. The helpline is for concerned persons who know about or hear about or have contact with a vulnerable elder who might be being abused. And this is an opportunity for those people who are concerned to really talk to someone, maybe get assistance or guidance, but also have a listening ear in a confidential way to really express their concern. What we have found and what the research has said is that if we can keep people connected with assistance for themselves, they will continue to be able to be connected with the vulnerable elders that they know about. So that is an enhanced service that really is directly for those who are concerned persons. And then we also do a lot of research. We also really participate in a lot of thinking groups to really move forward with the agenda of talking about vulnerable elders and abuse and the impact on all of us in society. So there are resources out there. Getting to the place where you have pieces in place for yourself and you've made decisions when you're able to make decisions in your life is so important. And that is what helps the professionals moving forward help to make decisions that you might want to make for yourself later in life when maybe you're not able to make those decisions for whatever reason. So thank you.
So I think we're just going to open it up to questions, and please try to keep your questions short and direct them to the panel.
Yes, I'd like to know if they have all those documents that you do in New York State, are they honored in other states and other countries? If you're traveling?
Right. Like a lounge lizard now. No, I'm not really sure about other countries. Theoretically, yes, but in other states, they would be honored with all of those documents, the wills, etc. As long as they were executed with the requirements required by the state in which they were created, every other state will honor them. Theoretically, I mean, it's an interesting question. I haven't actually been exposed. Maybe someone here has, but you know, I would think that if there was access to the document on the cruise ship, and if the person named as your agent was on the cruise ship with you, then it would probably be honored. But I'm not really sure. Cruise ships they're probably not set up for life support. I'm not, you know what I mean? Like, I think at that point, hopefully the cruise ship might return to port. And with other countries, you know, again, I would think that many countries are going to honor a document that they deem valid from the United States. But I couldn't promise you that in certain countries that may not share similar views when it comes to healthcare options or things like that, would necessarily honor it. I'll let Brad can choose. It is. Right. So it's what she's referring to is a couple years ago, New York State revised their estate tax laws. And so it used to be every estate over $1 million owed a certain amount of money on everything above that $1 million. They changed the law 3-4 years ago now or so, and they upped those exemption numbers. It jumped to 2 million and 3 million the year after, and now it's matched with what the federal number was before the most recent tax overhaul last year, where it jumped from about 5.5 million to 11. But New York didn't jump to 11 with the federal. But what you're referring to is called the estate tax cliff. And so if the estate, so right now it's, you know, let's just keep it simple. I'll say 5 million just to make it easy. So if it's 5 million, if the estate is 105% more than that amount, so 5 million plus who's good at math? 500. Thank you. All right, we'll use that. 5,250,000. If it's above that, you lose the full exemption all the way to $1, and you owe estate tax on every single dollar, even the ones below that 5 million. And everyone thought it was an accident or an oversight when it happened, but it was apparently done very deliberately. And I know that there is debate and discussion about it, but as of right now, it still exists. So what a lot of lawyers are doing now in a case where that cliff might be triggered is they put in what we call a Santa clause. And what that means is if the estate is going to go over that amount, the executor is authorized to give make charitable contributions until it gets under that amount, and those contributions are deductible. And so if you're 5.5 million, 5.5 million, the executor could give 250,000 or whatever it is to charity to bring it down under that 5,250,000. Well, it's the estate tax cliff is the problem, and the Santa Claus, it's not a legal term, it's just because it's gifting, so they call it a Santa Claus in the will. But it's important, but you have to that has to be in the will, because the executor can't just say, I'll just make charitable contributions. The will has to authorize that. So that's, the solution or the... It's when there's estate tax, when your assets are over a certain amount.
5 point something million.
Right. Right.
Estate is more than 5 point something.
Yeah, 5.8.
5.
Right. So anyone who's worth less than that 5.8 or 5.5 doesn't owe, there's no estate taxes at either the federal or the state level. So that's why I said it's a good problem to have, because if you're worth that much, that's a good thing. Yeah, then you would pay on the total. So it's good to try to avoid that.
What was that?
What's the percentage?
I mean, it's a range that tops out, I believe, at 16%. It starts a little lower, and it goes depending on what the actual number is. Oh, okay. I'll let you be the moderator.
I see one over there.
Absolutely. So, and I mean, it happens in scams. There's a scam called the grandmother scam. And some of you might be familiar with this, where someone calls you and they might sound like your grandson or your granddaughter. They happen to know your grandson or your granddaughter's name. And, you know, I'll pretend that Mike is my grandfather, and, you know, I'm calling Mike and I'm saying, I'm not me, I'm someone else. I say to Grandpa Mike here, Grandpa, I got into some trouble. I took a trip to Peru, and please don't tell Mom and Dad, but I really need $4,000. But because of all of the wire transfer fees and everything else, and this is a new one, instead of going to Western Union and wiring me the money, can you go to Target or CVS and buy $5,000 worth of gift cards? This is real. I'm not making this up. This is real. And I'll call you back tomorrow. I'm going to ask you to read me the numbers on the cards. Okay. Grandpa goes because Grandpa loves me.
He's trusting.
And he's trusting, and he goes and he buys the $5,000 worth of gift cards from CVS, Target, wherever he goes, and reads me those numbers. Those numbers are sold on the markets for a decreased value, and people use them. And they buy goods with them. And that's a real scam. The DAs in New York, but that's part of it too, because someone knew a lot about you in order to get to you. So they probably knew quite a bit about you already, and they might have already exhausted your social security number and other things that they might have had access to, and you might not have even known it. The DAs are involved in those scams, and it's really important, as soon as you know that someone close to you or someone might be susceptible to these scams, that you contact the DA, the local DAs, so that they can really understand what might be happening. If you have any information about it, the DAs are really, really involved in trying to get to the bottom of scammers. And the people who are in your house, the people who, we've heard of cases where home health attendants are scammers. And they're involved in not just one scam with one person, it's multiple people. And we've had the DAs be really successful in bringing charges, criminal charges against those people, those groups. In some cases, they get the money back. We are involved in what's called the Office of Victim Services funding, our program. And through the Office of Victim Services, people can recoup some of their money in addition to other losses that they may have suffered. So, I mean, it just means it's getting the people the services or understanding what's out there, what's going on.
Amazing, some people sleep.
I know, it's incredible. Well, they're in other countries too.
I don't even give a flat answer for that, because there's a huge range, as you said. There's people that'll do it for 300, there's people you're usually going to get, no matter who you work with, you're probably going to get the same, at least the 3 core forms I talked about: the power of attorney, healthcare proxy, and a will. Excuse me. What I like to do personally is when someone asks me, inquires about possibly working with me, is I have a questionnaire, an estate planning questionnaire, and then I ask them to fill that out, no cost or obligation, and then that allows me to assess the person's needs, and then I can quote a fee based on that. Because otherwise you're quoting a fee in a vacuum, and there's probably, I don't know, there's probably some lawyers who just say, no matter who you are or whatever, $1,500 or whatever. I just prefer to make, because if I don't know in advance what is going to be needed and what services and things you need, either I'm going to make a windfall or I'm going to be working for minimum wage if I just in a vacuum quote a fee. So I would just, if you're talking to different lawyers, I would think you want to go with someone you feel comfortable with and someone who is willing to give you the time of day to have a 10-minute conversation or something on the phone with you. It should be flat fee. I don't know of any lawyers who charge hourly for estate planning. I think it should be flat. I think most people charge flat fee, so you would probably want to avoid if someone was going to charge by the hour, because I think personally, if I was being billed by the hour for something like that, I'm going to be less forthcoming potentially with the lawyer, because everything I say is another second off the clock. Whereas you can have a nice, thorough conversation and a relaxed conversation and get the information. I can get the information I need. You feel comfortable conveying it in a relaxed way, and you're not worried about what's my invoice going to be. But yeah. I don't know that much.
Is that what's the deal on that?
I can leave it stat, but I don't. You mean like the person that you name in your will as an executor to allow them to have access to, so if you died, they would be able to access your savings account as well as, that would allow them access to the money, but it wouldn't allow them to put the money anywhere, and they don't have a duty to keep it unless you made them a joint owner, in which they are the they are the person who becomes the full owner. But if you just wanted to do it as a matter of, that allows my executor to get the money sooner to make the estate process go faster, I would say no, because the executor really can't do anything else until they have those court papers. And I also just think, as a practical matter, it's probably better to for every duty the executor carries out, for them to do it under the authority of a court appointed, with the court approval, and naming them as an executor, because they have to ultimately, when they close out assets, they put it into an estate account, a bank account, like a checking account. And then from that, they pay bills, and at the end of the day, they write checks to the beneficiaries. So if they were able to close your account, but you didn't want them to have the money, A, they could just run off with it, I guess, and B, they still can't put it anywhere until they're an executor with the authority to open a bank account in the first place. So, that's what I would.
So we have heard cases of about people who are in nursing homes, but nursing homes in New York State are under the Office of the Ombudsman, and we don't have jurisdiction. We can't put anything in place. The one thing that our teams are really good at doing is coming up with some outside resources that might be able to step in and help. So really looking for concerned persons who then can report to the Office of the Ombudsman and can follow through on all of those things that need to happen. Nursing homes are tricky. You know, they're under a different jurisdiction. I have heard of cases being open though, with nursing home, with people who've been in nursing homes. The other, a little nuanced and a little tricky. I recently heard about a case where someone was in a nursing home and they were being abused. They were being physically abused, and there was some financial exploitation that was also part of this. And someone was visiting them, and they called an ambulance. They called 911. Person came into the hospital, and then other people could step in. Adult Protective Services was called. So it was a nuanced way of getting the person help pretty quickly without going through that office and going through all of the red tape. So there are other, it was very clever, and it's a way to get people help. And visitors and concerned persons are the best eyes for they're the best eyes for situations like that. Yeah. Yeah. That's absolutely, it's a big question.
Quite a few years.
Yeah, it's the one that comes up most often that I'll talk about in answer to your question is there's a document called a Revocable Living Trust, which is basically a document that does what a will does, except if done correctly, you can avoid the probate process. There's a whole world of trusts, which obviously we won't go into, and some trusts can be written into a will, say a trust to provide for young children or minors who you might not even want them to get the money at 18, but maybe you'd like to have that paid out in staggered ways over the course of their 20s. So there's lots of different trust things that you can put inside a will, but I think the one that comes up most common is a separate document, this revocable trust. And in it, you name someone that would be you're a trustee of this trust that you set up during your lifetime. You name successor trustees, which basically will serve is the same functional role as an executor would serve if there was a will. And they would use the asset, and then you would also name beneficiaries of the trust. So if you died, who do you say, I give 20% to my kid, and whatever you do. And rather than an executor doling out money in accordance with a will, you have a trustee who's doling out the money in accordance with the trust. So it's I'm not a big proponent of them in most cases. They were very popular 10, 20 years ago. They're more functional in certain other states, but not maybe as much in New York, because the probate process in New York is not as onerous as I think is commonly believed. Whereas somewhere in Florida, I think it's common for even a basic estate to maybe take a year or two to be settled out, whereas in New York it can be a lot quicker. The key is with this kind of trust is that during your lifetime as a trustee, when you set up that trust, you then need to retitle all of your assets into the trust. So if you own a co-op or a condo or a house, you have to file a new deed or work with your co-op to transfer the stock certificate and lease into the name of the trust. And it's almost like it's not a taxable event. It's not like considered a sale. It's almost like if I changed my name from Mike Bond to Mike Band, I would have to go change everything because that's not my name anymore. So you're kind of just saying, if your name was John Smith and your condo was in the name of John Smith, you change it so it was John Smith as the trustee of the John Smith Trust. And if you do that fully during your lifetime, and all your assets are in that trust when you die, then your trustee can step in, and they don't need court authorization to serve as trustee. They can just do it, and they could take that trust document to a bank and say, I'm the trustee, I need to close out this account. But the problem is that almost inevitably something doesn't get put into the trust. And there's some asset when a person dies that is not in the trust. And so what most lawyers are going to provide, if you set up a trust, that kind of trust, a lawyer is going to usually provide you with what's called a pour over will. And basically that says anything I didn't put into my trust, I leave to my trust or to my trustee to put into the trust and distribute according to that trust. And so it's pouring over those assets into the trust, but you need to have a probate proceeding to do that. So you've lost the main benefit that most people see in having that trust in the first place, which is avoiding probate, because you have to go through probate to pour stuff into the trust. And in my experience, people don't. Some people do. My grandfather has put everything in the trust, and he keeps it very up to date, and so maybe that'll work out. And then if you own, not to go too much into the weeds, but if you own real estate in multiple states and you fully fund a trust, if you're in New York and you have a primary residence here, and let's say you have a summer house in Cape Cod, and you have a will, your executor has to have what's called an ancillary probate proceeding in Massachusetts to settle that real estate. If they're both in the trust, they don't have to have an ancillary probate because there's no original probate in New York. So there are some benefits in certain circumstances to having it, but as a blanket solution, I don't want to cast any aspersions, but I think they were all the rage 20 years ago because we charged twice as much to do it. And then if you also hire us to help you transfer assets, we bill you hourly for that. So there's a lot more money to be made by a lawyer to do it. And I think that the average cost of a regular probate proceeding is probably not much different. And most probate matters in New York are relatively straightforward. And I find that people who come through my door are happy enough that they just got through my door and they don't want to think about upkeeping a trust for the rest of their life. But it's a personal decision, so I usually discuss it with people so they can make an informed decision.
I'm going to go over here. I'm going to try to take
Yeah,
this
sorry,
one out.
that was a long-winded answer. You can't name your doctor unless that doctor was like your spouse or a relative that otherwise would qualify. I mean, it's probably an answer potentially too complicated, but I mean, a lot of it would probably depend on what the terms of the partnership agreement is. And oftentimes that sort of scenario will be, hopefully, be addressed in the actual agreement. And then if not, I think there's like a whole nother set of laws that govern things like partnerships and PCs and LLCs and all that sort of thing. And there's probably default statutory provisions for a scenario where that situation's not addressed. I just don't know that answer right off the top of my head. Do you know much about those? Most? Yeah, I mean, most is a document, it's an acronym, I forget exactly what it stands for. That's not something that I provide for people, so it's a document, to my understanding, it's actually, if in that AG, Attorney General document that you got, it's actually discussed, there's like a whole section on it, so you might want to refer to that as well. But it is a document that I believe you fill out at a hospital, and I believe each state has its own form, so you're probably not incorrect about that. It's just not something that, in my experience, is something that lawyers set up for clients. It's something that people set up with through their doctor or through some sort of a medical provider.
Okay, well, if you didn't get them, they'll be out.
Yes, I would just say, you really need to go once if you have your pension and certain other things, already beneficiary from the company.
I mean, in some cases, it's true that a lion's share of a person's assets are going to pass through things like designated beneficiaries, joint ownership, that sort of thing. But almost always there's some sort of a checking account, tangible property needs to be dealt with. But there is a proceeding in New York for any estate that's worth under $30,000 or $30,000 and less, and it doesn't mean only if the amount of assets that would pass through a will is under $30,000. You can go through this sort of short-circuited and much cheaper probate proceeding that's designed to be done without lawyers. In fact, a judge is going to look askance at a lawyer who's representing someone in that kind of situation because the filing fee is like $1 instead of several $100s. So it might be that if you could have $100 million in a retirement account, but if only $25,000 is passing through probate, you could use this short-circuited proceeding. And it's possible you could have nothing, and if you have a spouse, there's a certain amount of property, and it's delineated in a statute, but there's a certain amount of items and a certain amount of cash, and the family Bible and a car and up to 25, it's very specific, farm equipment, that can pass to a surviving spouse automatically and without any probate proceeding. So in a lot of cases, in a situation where there's a married spouse, there might not be that much outside of designated joint ownership and beneficiary designations, and everything can be encompassed under that law that provides for spouses. So any executor, regardless of whether it's your spouse or whether it's a friend or your uncle or your son or whatever, is entitled to a commission. And it's a breakdown that's written into a statutory code, but it usually averages out to roughly 3 to 4% of the assets that pass through the will. It does, or through the probate aspect of the estate. So if you have a $3 million life insurance policy, they don't get 3% of that because they didn't do anything. I mean, that's something and if you left a Van Gogh painting to a person, they don't get a commission based on what that painting is worth because all they're doing is handing over a painting. So it's designed to be make it worthwhile for an executor to not renounce the job and actually take it, but it's not meant to be a windfall. But if you happen to be the executor and the sole beneficiary of an estate, you're probably going to waive the commission because the commission is considered income and the inheritance itself is tax-free. So why would you take money that's going to be taxed? If you pay me. I mean, basically, most lawyers are going to create their own documents or use documents they got from the person they worked for first 30 years ago or something like that, and then sort of update them through time. And so we all have like a basic template, and then we custom tailor it to that's sort of like our intellectual property. So yeah, I don't post it online. Certainly, yeah. Yeah, so they get a commission. It's determined by a calculation that can get complicated. It usually averages out to roughly what a executor would get, and there's a commission based on the principal of the trust, and then there's another sort of annual type commission that would be based on, I think, distributions made from the trust and income coming into the trust. So it could come out to be, it would be two different calculations. It would probably all be paid at one time during the course of a year. So like I said, ideally you want to name beneficiaries on the accounts, but let's say you forgot, or let's say all those beneficiaries predeceased you and you just never updated the form. If that financial company has no one around who's alive to take that money, it'll pay out to the estate, and then it'll be distributed according to the will. So it's not like that money's forfeited or anything. It's just that instead of it being written to Mike Bond, it would be written to like the estate of John Doe, and then the executor would put it into that account and distribute it. And if your will left everything to 3 different charities, for example, those charities would be the beneficiaries ultimately of that money. It would certainly take a lot longer because you have to wait that 7 months and you have to go through the whole probate proceeding before. Right. Well, so you're talking like with IRAs and things like that. If someone dies with an IRA, 401k, or those sorts of things, and they name a human being as the beneficiary, and that human being is there, they have a lot more options to get an inherited IRA and to allow that to continue having some tax benefit over. They don't have to cash it out right away if they don't want to. But yeah, if it was paying to an estate, it's just going to be cashed out. And then if there was any penalties or tax associated with that one-time distribution to the estate, then that would be tax that would be payable by the estate. I mean, I can't really speak to what happens while you're going to a bank during your lifetime trying to manage your own accounts. But if an executor goes to that bank and they have that court paper, the bank has no. I mean, they have to comply. I mean,
I don't think we're going to be able to resolve what happened. Any other questions? I have one question. So if I have a living will and a healthcare proxy, is the healthcare proxy obligated to follow what's in the living will, or what is their discretion around that?
yeah, I mean, if there is a living will, yes, then they have to follow the terms of the living will. Now, generally speaking, a lot of living wills will, the language of it is such that there is some latitude perhaps for the agent to be able to make decisions in particular circumstances, because obviously no document can address all circumstances and that might arise. But they can't say, well, she told me last night or last week, so we're going to, because the document's governing.
Well, thank you so much for your presentations. And if anybody missed any of the handouts, there are those handouts and many more out on the tables in the front. And we'll also be putting a video of this on the web so you can revisit it. Thank you all.